Hello everyone, in today's video I'll be talking about one of the most important and most common immigration topics that I handle as an immigration attorney, the marriage-based green card. Although it's a common procedure, it can sometimes feel like a maze of legal requirements. Now, I can't cover everything from A to Z in a single video, but I'm going to cover the fundamentals from eligibility to common mistakes. And if there's anything I don't cover, leave your questions about it in the comments and I'll make other videos to answer them. If this is your first time on the channel, make sure to subscribe and turn on the notifications so you can receive my latest videos. Now, first thing, eligibility. Eligibility for a marriage-based green card hinges on a legally recognized marriage, the sincerity of the marital relationship, and adherence to immigration laws. Meaning, your marriage must be legal in the place it was performed and recognized by U.S. immigration law. This includes same-sex marriages, which are treated equally under U.S. immigration law. Proving your marriage is bona fide or genuine is critical. This means that you didn't get married just to circumvent immigration laws. There are also other general requirements such as entry with inspection and not being inadmissible. But how do you prove love and commitment on paper? Here are a few ways. Documentation is your storytelling tool. Beyond the marriage certificate and legal documents, you'll need to weave a narrative of your life together. This includes joint bank accounts, lease or property ownership documents, and photos of shared experiences. But what truly counts as sufficient evidence? It's not just about quantity, it's a story it tells. Did you take vacations together? Do you share responsibilities? Letters from friends and family attesting to your relationship, joint memberships, and shared finances, all of these can help. Even shared streaming service accounts can add depth to your story. Now, is there an income requirement? Yes, the U.S. citizen spouse needs to make a certain amount of income to sponsor you. Currently, for a household size of 2, the income requirement is $24,650. The next step is filing the application forms. If your spouse is outside the United States, they are not eligible for adjustment of status and will need to obtain their green card through consular processing. Be sure to fill in the forms correctly and accurately. Insufficient information or missing evidence of a bona fide marriage can derail your application or lead to a denial. Failure to provide necessary documents can be fatal. It is always a good idea to have this taken care of by a lawyer. As the application progresses, you may or may not be interviewed. If an interview is scheduled, you should prepare well. Now, I'm going to answer some of the most frequently asked questions to shed some light on the common concerns. Question number 1. My spouse and I don't have joint bank accounts. Will my green card application be denied? This alone is not grounds for a denial. It is okay to have separate accounts as long as you have other evidence to help your case. It's about the totality of the evidence, not one particular piece on its own. Show your integration in other ways, like joint leases, insurance policies, or shared investments. Question number 2. How long does the process of a marriage-based adjustment of status take, and is there a way to expedite it? Timelines vary based on individual circumstances and current processing times. Generally, it can last about 1 year, but this can fluctuate. Unfortunately, there's no way to expedite the process, as premium processing is not an option for marriage-based green cards. Making sure that your application is free from errors and providing all the required evidence can help avoid delays, so be sure to get it right from the beginning. Question number 3. What if my spouse is not in the U.S.? Can they still apply for a marriage-based green card? Yes, they can in cases like this. Consular processing is your pathway. It involves a foreign spouse applying for a visa outside the U.S., which becomes a green card upon entry. The process can be complicated, requiring coordination with the U.S. consulate or embassy, so be sure to consult with an immigration attorney to help you complete the application correctly. Question number 4. Can previous marriages affect my application? Yes, but it's about transparency. Make sure to provide divorce or death certificates for the previous spouse to demonstrate that your current marriage is legally valid. A previous marriage on your record can make the interview a bit daunting, but it's a chance to show the authenticity of your current marriage. Dress appropriately, be punctual, and answer questions truthfully. Practice commonly asked questions together, and remember, it is okay to have individual memories and perspectives. Consistency is key, but so is authenticity. Having a lawyer can ensure that you are adequately prepared for the interview. Generally, you must be married based on the laws of the United States or a foreign country, so proxy marriages without meeting your spouse can be problematic. Now, the last thing I want to talk about is something that many people unfortunately fall for: scams. There are a lot of those out there. If you ever get an email or a text from someone, or even what looks like a government institution, be skeptical. Scammers will almost always offer guaranteed outcomes and ask you for money up front. But with immigration, there's never a guarantee. The law is complex and every case is different. Always get professional advice from a reputable source. If you found this video helpful, please click the like button. It helps these videos reach more people who need them. And remember to subscribe and turn on the notifications to get my latest videos in time. Thank you for watching, and I'll see you in the next video.